Today, I'm joined by two old friends who happen to write one of the best books ever on how to ace your test scores to get into law school. Hello, and once again, this is Lavetta Jenkins, guest host of Break into Law School. Jeremy Paul served as Dean of Northeastern University School of Law from 2012 just until June 2018. He teaches constitutional law, property, and jurisprudence and co-directs the university's media advocacy program. A 1978 graduate of Princeton University, he received his law degree from Harvard in 1981. Before coming to Northeastern, Professor Paul served for 23 years on the faculties of University of Connecticut School of Law, where he was dean, and the Thomas F. Gallivan Jr. Professor of Real Property Law from 2007 to 2012. Michael Fischl is Constance Baker Motley Professor of Law at the University of Connecticut. After graduating from Harvard Law School in 1978, he spent 4 years with the Division of Enforcement Litigation at the National Labor Relations Board and a year with the Litigation Unit of California Agricultural Labor Relations Board. Together, these two wrote a book called Getting to Maybe: How to Excel on Law School Exams that I feel is one that will help everyone break into law. I'm joined with both of them who wrote this wonderful book today. Hello, gentlemen. How are you?
Great. How are you?
I'm doing amazing, doing amazing. So, we've got to talk a little bit about this. I know you two have a long history together. So, I've got to ask you all about this amazing book that you two co authored. It's called Getting to Maybe: How to Excel at Law School. Whose idea was it to come up with writing a book to help others get into law school?
I'm not entirely sure you can attribute this to one of us. What did happen, and this might be of interest to your audience, is that we were both asked, along with several other faculty members, to do a presentation to the chapter at Miami of the Black Law Students Association. We had a great time doing it. We chatted a little bit in advance. And when I sat and listened to Michael, I thought, God, that was a really great presentation. And so just on a lark, I asked the librarian at Miami, we just did this presentation. Let's see what's out there. Mm-hmm. And they wheeled to my office 2 full carts of books, at least 100 books about how to succeed in law school. But of all 100, not one was about exams. So you'd pick them up and you start looking, and there'd be like a little chapter, and the chapter would say, go to class, get some exercise, go to the movies the night before, little things like that. Meanwhile, what we knew as relatively junior faculty is that the project of doing well in exams was something that you really ought to be thinking about from the moment you got there to the moment you were done. And there was a lot of substance to it. It's not just how to study so you don't get overtired. There's actually a skill to it. And not only is there a skill to it, but it's one that we thought was not well taught at law schools and that we could, in fact, explain. That's really, I think, what led us to, so it was, I would say, as a team effort as to the idea that we were going to actually tackle this book. And also, we had a repeated experience that we would sit in the faculty lounge with people who've been teaching 30 years, and they would be complaining about the students. And first of all, both of us had a very strong negative reaction to ever being complaining about the students. Mm-hmm. Students are great. If there's a problem, it's with us, right? But the nature of the complaints was that the students think that there are right answers. Mm-hmm. And don't they understand that the whole point of law school is that there aren't right answers. There's multiple answers, and you have to make arguments both ways. And why can't they get over their right answer fetish, so to speak? And what we would say to them is, well, at the end of the semester, are you going to give an exam? And they would say yes. And they would say, well, are you going to grade the exam? And they would say yes. And they would say, is it going to be hard for you to decide who gets an A and who gets a C? And they would say, well, it's really hard to decide between a B and a B+, but between an A and a C, that's a really easy thing to tell, and everybody can tell. And we would say to them, a little teasingly, but also a little mockingly, well, you know what? From the point of view of the students, the people who have the A's, they have the right answers. So when you say to them that there's such thing as right answer, that's not really what you mean. What you really mean is that a right answer is a complicated answer. And a right answer is one that takes into account both sides of a discussion. And if that's what a right answer is, who's going to explain to the students how you get to that kind of a right answer? And that's ultimately what led us to write the book.
Ooh, that was a very good answer. Professor Paul. So, Professor Fischl, how long would you say from start to finish, literally from the time you thought about it until the time you literally held it in your hands? How long would you say the writing process was for this particular book?
We didn't hold the book in our hands until 1999, but we really began writing in earnest. We got everything, other things off the decks, got them cleared, had lots of babies between us and that. And I would say that in December 1996, we began working in earnest. And so it really was 2.5 to 3 years from we didn't put pen to paper, putting fingers to keyboard to the time that we saw it.
Now, I know it took a lot of research, even though this is your field of expertise. But Mr. Jeremy Paul, I would like to know, what do you think was one of the hardest things to kind of convey in the book that you really, really wanted to get out to someone?
Well, I think one of the things that was hardest to convey was the relationship between the skills we're seeking to describe and not just exams, but what it's going to be like to be a lawyer when it graduates. Because, I've have a lot of friends who are not either lawyers or certainly not law professors. And when I say to them, it didn't take us all 13 years, but it certainly took us a lot of time devoted to the study of exams, they would look at me and they would say, you only have one life. And in that one life, you're spending it on like law school exams. Why is that a topic that's of such great interest to you? And of course, my reaction to that firstly was, well, the students care a lot about it. And so that's something that people should really do. But beyond that, it seems to me that the skills that we seek to impart in the book are not merely relevant just to doing well in exams, even though that's in the subtitle, but also to what it means to be a critical thinker. And really, ultimately, the point of the book is called Getting to Maybe, because we want to encourage people to understand that there are often strong arguments on the other side of an issue that might not immediately appeal to you, but that might be convincing to someone else. And therefore, you might want to be a little more humble about all of the opinions that you think are so certain, so that it really is a book that goes well beyond just exam taking skills.
Mr. Fischl, I have a question for you. What do you think is one of the largest misunderstandings when it comes to taking tests for law school? What's one thing that you can see people doing most wrong?
I think there is a tendency for law students, if you will, to take what they did successfully as undergraduates and try to transplant it without alteration into the law school setting. And you can get why they might want to do that. They did well as undergraduates. And so they figure, well, that worked for me then, it's going to work for me again now. And the problem is there is a major shift in what exams call for when you move to the law school setting. And it has to do with, as Jeremy was just describing it, with critical thinking and not stopping with the obvious. And it's this. The law school exam isn't asking for you to regurgitate information. Students, if you ask them what's the law, they will immediately rattle off a bunch of rules that they've learned. And they would think on the law exam, my job is to rattle off those rules as quickly as my fingers can accomplish that. But in fact, we ask for on the exam is for them to use the rules in order to solve and address human disputes. That's the link to lawyering, because that's exactly what lawyers do with it. No client in the history of the universe has gone to a lawyer wanting a law lecture. Like, tell me the rules. They go with a problem. And so it is the capacity to bring the rules, the other legal materials, bring them to bear on an analysis of a problem. That's the lawyering skill. And if you will, the secret to law exams is that that's the lawyering skill they test.
Mr. Paul, do you also think that it's the same exact thing, or do you have a different view of what you think the most common mistake is?
Well, I think the most common mistake is students don't understand that what they need to do is answer the question that's asked. We have a standard joke that, they say that the three most important things in real estate are location, location, and location. Well, the three most important things for doing well on law school exams is answer the question, answer the question, answer the question. And it's just so easy for the students. And this is really a variation of what Michael is saying. It's so easy for the students to start reading and think, oh, this is a question about adverse possession, or this is a question about breach of contract. I know a lot about adverse possession, or I know a lot about breach of contract. So I'm going to tell the professor everything I know about that. And how could I possibly not do well? And of course, out that that's not what you're supposed to do. It's one of the reasons why many students who are actually very good students and really do know a lot of what they're supposed to be doing don't perform as well as they would have hoped to do. And actually that leads into a point about sort of where we are in the process with the book, which was that it was precisely because of that, that when we wrote the book the first time, the 13 years time that Michael referenced, we imagined that students would be reading it in February after they had taken their first set of exams. Shockingly, 90% of the students would discover that they were not in the top 10% of the class, and they would be disappointed. That would certainly have applied to me as well. Then we needed some help. But what we learned after the book was published was a lot of professors at schools really enjoyed the book and started recommending it to people for the summer before law school started. So in the second edition, the one that's just out in this past July, we added a whole lot of new material aimed at students who are going to read the book before law school starts or early in the beginning of time, so that they can study with the exam in mind, they can outline their material with the exam in mind. And that really was one of the major changes in the second edition, which, as I said, was just put out in July.
So I do need to ask Mr. Fischl this question. Out of all of the things that you wrote, that both of you wrote in the book, what's the one thing you wish you had known going into law school that you had to make sure you included in this book?
We developed the insight that the reason that students don't argue both sides on a law exam, the reason why many of them don't, is not because they don't see two sides. It's because they think they're supposed to come up with one right answer. That, again, is undergraduate training. It's also a lay impression about the way law works, that law will have one right answer. And so when the student goes, wow, this case is a lot like this case that we studied, but there's some differences. How am I going to choose whether we follow the case or we distinguish it? And kind of like Dorothy and the ruby slippers and the Wizard of Oz, they've got the ruby slippers. They actually are seeing both sides, and they have to slow down and understand that what the question is asking them to do is to talk about both sides. They may come to a conclusion that one is better than the other. They may come to the conclusion that it's a really tough call and it would depend on the court. But law professors seldom test questions that are so straightforward that there is only one possible answer. And yet the students are coming into the exam thinking there's only one possible answer. I wish I'd known that in law school, because I was forever being subjected to these classes where we were learning how complicated the world was, the world of law, the multiplicity of possibilities in various areas of the law. And then I'd get to the exam and act like, well, there have to be answers to these questions. So I wish I'd known that then, because if I had, I'd be rich.
I would like to pose the same question to you, Professor Paul. What do you think that is in this book that's something you wish you had known going into law school?
So as a student, I was pretty active in discussions in class. And one of the things that really frustrated me was the professor was in front of the class trying to tease out, well, you could look at it this way, or you could look at it that way. And I, as a student, was like, I would raise my hand and say, well, all right, so you could look at it both ways. What's the right way to look at it? Tell us what the solution would be. Sort of as a naive young person, I would look at these faculty members who were significantly older than I was. You've been out working all this time. Haven't you figured it out by now? Right? And so I actually now, with my students, I give them an exercise in which I ask them to make a 5-item grocery list and then pass the list to the person next to them to take it to the store and shop. And invariably, right, the list will include things like milk, bread, pasta, right? And then the person who's reading the list will start reading it off, and I'll stop and say, oh, milk. Okay, you're supposed to get milk. What kind of milk are you going to get? Are you going to get dairy milk, whole milk, skim milk, 2% milk? How much milk, right? And then I do the same thing with the other items. And of course, the point of this exercise is that here you have two people trying to cooperate. One is writing a note to the other, go to the store and buy these things. And even in that context, the description of what needs to be done is so indeterminate and so vague that the person in the store better have their cell phone so they can call up the person and say, well, you wrote milk. What kind of milk do you want me to get? How much shrimp do we need? What kind of pasta do you want? And so that's a situation where people are cooperating. But of course, in law, people are fighting with each other. So it's crucial to them that they be able to present alternative points of view, because if they get their way, they win the case. Otherwise, they lose the case.
I never thought so in depth about my grocery list as I do now, because in my mind, I know it's almond milk, but all I wrote was I need to get milk from the store. Never thought about it that way. That was a very, very good analogy. Mr. Fischl, I've got to ask you, if someone was on the fence about getting this book, what would you tell them to really make them want to purchase this particular book?
Well, I'd start by saying it would contribute to the retirement funds of some very, very nice people. But beyond that, I would say I would let people who have found the book crucial to their own law school success, I would let them do the talking. And the particular audience or population that I would point to, I have many times at the University of Connecticut and before this at the University of Miami taught a spring academic success course, second semester of law school. And in both institutions, it was designed for people for whom the first semester had not gone well. And so they wanted a restart. They wanted a redo. And the first time I taught it at Miami, actually getting to maybe was in draft. They were getting page proofs to work with. But since then, I've been using getting to maybe. And mind you, students who take a course like that, both Miami and UConn, it's voluntary. We don't force them into the class. They know it didn't go well for a semester and they're motivated to try to change it. So that's a select group in that respect. But every one of them, as we work through getting to maybe, improves their skills. And I watch students who have C plus averages end up well into the B range at the end of the second term. And the last time I taught the course, all of the students were above a 3.0 by the end of the third semester,
Wow.
which was a good thing because then the pandemic came and all bets were off.
Right.
But the point is, it is a tried and true route to concrete success in law school. And some of the students who face the greatest challenges can give the best testimony to that effect.
I love it. And that is the best thing you can do, is let the work speak for itself. And I think that it most definitely has, because it's back out there again, still helping students get to maybe, especially when maybe seems so far away if you have not done well in your first round of testing. Has to be astronomical. Professor Paul, I'd like to have you have some closing remarks on what you feel this book could really, really help those who are struggling to get to maybe. What would you tell them?
One of the things that's the most difficult about being a student who's not doing as well as one hopes is that it is very difficult to figure out why. Very few faculty members sit down with student exams and really go over them super carefully and provide written comments back to students. And even those that do, one of the things that characterizes a lot of people who are law faculty is that they themselves were spectacular students. And therefore, it's very difficult for them to imagine why other people are not such spectacular students. And so the reason why I think this book is really different than others is it moves very slowly and it really fills in the gaps. We worked very hard to make it readable. We put in some jokes. Michael has a gift for that, and I just sort of I'm along for the ride. So it's very readable, but it's not Cliff Notes. It's not law exam for dummies. It's nothing like that at all. In fact, it's the opposite. This is really what law school is seeking to enable you to accomplish. And we're just going to slow it down for you so that to the extent that there are places that you're not with the program, you'll get with the program. And, we're very proud of it. And I really believe it would be helpful to almost all students.
Thank you. I've seen the reviews and I can truly say this is something that you need to be extremely proud of. I want to thank both of you for your time. You have been amazing guests. I really have appreciated having you, and just for you explaining how getting to maybe can help so many. Thank you.